It was 1996 when Senator Ted Kennedy brought the issue of ending discrimination in employment to the floor of the Senate. And in that year, not so long ago, virtually everything was simple majority in the Senate as designed by our founders, as written in the Constitution. And the vote failed, 49-50, because Senator David Pryor was at the hospital attending to his son, the future Senator Mark Pryor, who had cancer. It was a moment where the Senate nearly took a big stride forward, ending discrimination in employment in America against our LGBTQ community. Then in November 2013, I brought to the floor the same bill, ending discrimination in employment. And this Senate voted in a bipartisan majority to end that discrimination. In fact, the vote was 2-1, 64-32. But that bright moment here in the Senate, where we stood for the vision of freedom, was not acted on by the House, and the bill did not make it to the President's desk. And now we stand here today in 2020, and the Supreme Court on Monday in Bostock versus Clayton County, in a 6-3 decision, has proceeded to act to end discrimination in employment. In writing the opinion, Justice Gorsuch said in Title VII, referring to the 1964 Civil Rights Act, in Title VII, Congress outlawed discrimination in the workplace on the basis of race, color, religion, sex, or national origin. Today, he wrote, we must decide whether an employer can fire someone simply for being homosexual or transgender. Everyone looked to the next paragraph, and what would the answer be? And Gorsuch wrote this. The answer is clear. An employer who fires an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned if members of a different sex. Sex plays a necessary and undisguisable role in that decision, exactly what Title VII forbids. Well, let the bells of freedom ring here in this chamber and across America. On Sunday of this last week, the day before the Supreme Court decision, discrimination in employment against gay and lesbian, transgender, bisexual Americans was still legal in 29 states, the majority of states in our country. And on Monday, that discrimination ended. It is now illegal in all 50 states of America, in all territories of America, to discriminate on the basis of who you are or whom you love. The court took a long, powerful stride toward the vision carved above the doors of the Supreme Court: equal justice under law. No longer can a mental health counselor named Gary Bostock be fired from his job at a child welfare services department for playing in a gay softball league. No longer can a skydiving instructor named Donald Zarda be fired because he is gay. No longer can a police officer in Southern Oregon named Laura Elena Calvo, with a sterling 16-year record of promotions, commendations for pulling people from burning cars, delivering babies on the side of the road, saving lives, and more, be fired because she was a transgender woman. And so employment discrimination ends in America. Let us savor that victory for freedom. Let us celebrate that victory for equality and opportunity. It is a long, powerful stride forward on the march for freedom. But a long stride forward in a march however significant, does not mean that the march is over. Because as wonderful as that victory on Monday was, as wonderful it is to have discrimination end in employment across the land, we still have a long ways to go before LGBTQ Americans are treated in every part of our national life as a person equal in dignity and promise to all others. The protections on Monday involve employment, but those protections do not extend to the titles of the 1964 Civil Rights Act that address other issues of education, issues of public accommodations, and they don't extend to credit, financial transactions covered by the Credit Act. They don't extend to jury service. They don't extend to federal funding of programs, meaning it is legal for states to discriminate, or cities to discriminate, or counties to discriminate on the basis of federal law against participation in federal programs. It's unbelievable that we are still in that state, but that is where we are. That's where we are right now, with discrimination ended in employment, but not ended in all of these other categories. Now, there's a couple possible paths forward. One is litigation that continues on the same premise on which the Supreme Court acted on Title VII of the 1964 Civil Rights Act. And that means litigation in each of these categories, case after case, slowly making its way through the courts, slowly making it to the Supreme Court, meaning discrimination continues for year after year after year while the courts deliberate on this. I've heard a number of senators say, the court acted, but Congress should have done it. Well, now we have the opportunity to do it. We have the opportunity to do it by putting the Equality Act on the floor of this Senate, putting it on the floor of the Senate today, having a debate today, having a vote today on whether to extend the very premise at the heart of the Supreme Court's decision in employment to all the other key areas of discrimination that are still suffered across this land. Let us put the Equality Act on the floor. Let us debate it and let us pass it to fulfill the vision Thomas Jefferson put forward when, in the words he crafted for the Declaration of Independence, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among them are life, liberty, and the pursuit of happiness. Let us put the Equality Act on the floor of the Senate. Let us debate it, and let us pass it to act on the premise that Senator Ted Kennedy expressed. The promise of America will never be fulfilled as long as justice is denied to even one among us. Let us put the Equality Act on the floor of the Senate and debate it and pass it to fulfill the promise of freedom, that President Johnson so well expressed, the right to be treated in every part of our national life as a person equal in dignity and promise to all others. We have the power to ring the bells of freedom here in this chamber. Let us not miss this opportunity. I am so pleased to be here with my colleagues who have fought for this vision of freedom and equality and opportunity. Colleagues Tammy Baldwin from Wisconsin, colleagues Cory Booker from New Jersey, who have been champions in leading this fight, a fight envisioned by now a tremendous number of senators endorsing and co-sponsoring the Equality Act. Let us put that act on the floor. And I yield to my colleague from Wisconsin.
Mr. President, I rise today to recognize an enormous step forward for our country that happened earlier this week on Monday. Once again, on a morning during Pride Month, our nation came closer to realizing the promise of equality for lesbian, gay, bisexual, transgender, and the queer community. The Supreme Court has made it clear that workplace discrimination against LGBTQ people is wrong, and our nation's civil rights laws prohibit it. While this is a joyous day and a joyous week, I want to take a moment to acknowledge the untold number who have suffered in this country for years without a recourse. I want to recognize those brave LGBTQ people who received pink slips, were passed over for promotions, suffered harassment and bullying in break rooms, or never got that initial interview, all simply because who they are or who they loved. I particularly want to thank the plaintiffs who brought this case: Gerald Bostick, Amy Stevens, and Donald Zarda, as well as the families and friends and lawyers who supported them. Sadly, Amy and Donald did not live to see this transformative moment for our country and our community. But we will remember them and honor the efforts that they and so many others have made to get us here. And we'll commit ourselves to continuing the push forward for full equality for them. On Monday, the Supreme Court affirmed what many federal courts, the Equal Employment Opportunity Commission, and so many of us has recognized for years, that Title VII of the Civil Rights Act of 1964 is properly understood to prohibit discrimination based on sexual orientation and gender identity. As Justice Gorsuch wrote for the majority, and I quote, "Today we must decide whether an employer can fire someone simply for being homosexual or transgender. The answer is clear. An employer who fires an individual for being homosexual or transgender fires that person for traits or actions that it would not have questioned in members of a different sex. Sex plays a necessary and indisguisable role in this decision, and that's exactly what Title VII forbids." Now, this decision is far from radical, but it is transformative. It means that at long last, in every corner of this nation, in big cities and small towns, LGBTQ people are waking up in a fairer country. They now know that they have recourse if an employer discriminates against them simply because of who they are or who they love. And employers know unambiguously that they have an obligation in every state to judge all of their employees on merit, not sexual orientation or gender identity. While we have taken another big step forward, and it is a big step, in the march towards full equality for LGBTQ Americans, we are not there yet. Lesbian, gay, bisexual, transgender, and queer people face discrimination in many more aspects of their lives than the workplace. Our country needs to send the message that treating people unfairly because of their sexual orientation or gender identity is wrong, and that it won't be tolerated, period. Whether that's while buying a house, going out to dinner, shopping in a store, serving on a jury, or seeking help from a government program. So while the court told us on Monday that discrimination based on sexual orientation or gender identity is necessarily sex discrimination, those cases were about employment. And while I would expect that any administration would now take a long, hard look at its wrong-headed efforts based on the legal arguments that the Supreme Court has just rejected to write LGBTQ people out of sex discrimination protections in education, healthcare, and other areas, I do not have confidence that this administration is going to do so. And there are areas of federal civil rights law, like those governing public accommodations and federal financial assistance, which don't even yet prohibit discrimination based on sex. And that is why the Senate must take up and pass the Equality Act. Senators Merkley, Collins, Booker, and I introduced this bipartisan measure to ensure that LGBTQ people have the same non-discrimination protections as other Americans by adding sexual orientation and gender identity alongside all protected characteristics like race and religion to existing federal laws. It would ban discrimination in a host of areas, including housing, public accommodations, jury service, access to credit, and federal funding, as well as employment. The bill would also strengthen our civil rights laws by adding protections against sex discrimination to the federal laws where they have not been included previously, including those addressing public accommodations and federal funding. More than a year ago, a bipartisan majority of the House of Representatives passed the Equality Act. Unfortunately, like so many other pieces of legislation that would improve the lives of the American people, it has been ignored by the Senate Majority Leader and placed in his legislative graveyard. The Equality Act cannot be ignored any longer by the Senate. And LGBTQ people should not have to wait any longer to enjoy the full protections of our nation's civil rights laws. I urge this Senate to build on the Supreme Court's decision and act today to bring our nation closer to the promise of equality by passing the Equality Act. Finally, I want to close by acknowledging the extraordinary moment in which our nation finds itself today. Thousands upon thousands are demanding the country confront racial injustices and systemic racism. They rightfully call for change, and they righteously call for change. And it is my hope that Congress will take an important step in righting some of those wrongs by passing the Justice in Policing Act of 2020 without delay. But we must do so much more. And today I'm keenly aware of the Black and brown LGBTQ people who experience discrimination and injustice in this country, not just because of sexual orientation or gender identity, but also because of race or ethnicity. As we approach another anniversary of the Stonewall riots that sparked the modern LGBTQ movement for equality, I'm also mindful of the leadership of Marsha P. Johnson and Sylvia Rivera, transgender women of color, in that historic moment. I hope the brave, courageous legacy of these leaders and the urgent needs of Black and brown LGBTQ people will inspire us to take another step to strengthen the civil rights promise for all Americans and pass the Equality Act. And I would now yield to my colleague from Michigan, Senator Stabenow.
Mr. President.
Senator from Michigan.
Thank you. First of all, I want to thank my wonderful colleagues for their leadership, Senator Merkley and Senator Baldwin, for not just being on the floor today and speaking out, but speaking out every day for introducing the Equality Act, of which I'm very proud to be a co-sponsor and for continually standing up for the rights of all Americans. In 2013, a Michigan funeral director wrote a letter. It said, "What I must tell you is very difficult for me and is taking all the courage I can muster. I have felt imprisoned in a body that does not match my mind. And this has caused me great despair and loneliness." She told her co-workers from now on she was choosing to live her truth. From now on, she would be living and working as a woman. Unfortunately, she paid dearly for her courage, and 2 weeks later, she was fired. That woman was Amy Stevens of Redford, Michigan. This week, Amy's courage literally changed history. Literally changed history. In a 6-3 decision, the Supreme Court ruled that what happened to Amy was illegal. It was illegal, period. Employers cannot fire or otherwise discriminate against employees simply because of who they are or who they love, period. Sadly, Amy didn't get to celebrate this landmark victory, and we all wish she was here right now to be able to join and lead the celebration. She died last month at age 59. She will go down in history as someone who took a stand for equality, for basic fairness, and made our nation a better place. And so many people have joined her in this fight, getting to this victory. It's now time to further honor her courage and the courage of so many others by passing the Equality Act. And we can do it today. That's the good news. Right now, on the floor today, we can do that together. What a great way to end this week, this month of June, this Pride Month. What a great way this would be. The Equality Act is pretty simple. It protects people against discrimination based on sexual orientation or gender identity in all aspects of their lives. Unfortunately, this legislation, as my colleagues have said, which has already passed the House, has been sitting on Mitch McConnell's desk gathering dust for nearly 400 days. 400 days since the House of Representatives took action. It is time to shake off that dust and get this thing done. For Amy and for everyone who has fought alongside her and continues to fight today to make our nation a more equitable place. Now, our Republican colleagues, however, are more interested in pushing through extremist judges who have no interest in LGBTQ equality. Later today and next week, we'll be voting on 2 judicial nominations, Justin Walker and Corey Wilson. It's frankly insulting that these 2 nominations are even coming to the floor. Insulting to the American people that they are coming to the floor. Justin Walker's nomination is opposed by 275 outside groups, including the Leadership Conference on Civil and Human Rights, Lambda Legal, and the National Center for Transgender Equality. As for Corey Wilson, he supports HB 1523, the so-called Protecting Freedom of Conscience from Government Discrimination Act. And that would give broad permission for people and businesses to deny services to people based on sexual orientation and gender identity. Both of these nominees, both of them, would overturn the Affordable Care Act, which has made life-saving differences for so many members of the LGBT community and Americans all across our country. Justin Walker wants the courts to throw out the entire ACA, including protections for people with pre-existing conditions. He called the Supreme Court decision upholding the ACA indefensible and catastrophic. Millions of people getting their health care through the Affordable Care Act. Everyone who has an insurance policy being able to do that and get covered even if they have a pre-existing condition because of the Affordable Care Act. Corey Wilson used even more colorful language. He called the law illegitimate and perverse. Providing people health care, he thinks is perverse. And this is somebody that the Republicans are going to put on the courts. He even opposed expanding Medicaid coverage in Mississippi, a change that would literally save lives in the middle of a pandemic. We know what we need to do because Amy showed us. We need to pass the Equality Act now, today. We can do that today. Wouldn't that be wonderful on a bipartisan basis to pass this today? And we need to vote no on 2 judicial nominees who are far out of step with the basic American ideals of equality and fairness. Amy Stevens was courageous. 400 days is way too long for millions of Americans to wait for the United States Senate to step up and do its job. It is time for all of us to truly stand up for equality for the LGBTQ community and set the foundation that we believe in equality for all Americans. Thank you, Mr. President. I yield the floor.
Senator from Oregon.
Mr. President, before she leaves, another good idea from Senator Stabenow. Pass the Equality Act today. Too logical, I guess, but it's another good idea, and I thank my colleague for it. I also want to commend my partner from Oregon, Senator Merkley, who's been leading this fight for years now, and Wisconsin often partners with Oregon, going all the way back to our shared ownership of Wayne Morris. And I just want to thank my colleagues for the great work they've been doing, and just take a couple of minutes to talk about my pride in standing with them to fight for the passage of the Equality Act. We've come together during the middle of Pride Month, and in 2020, with the pandemic continuing to spread, Pride Month looks a little different than it has in the past. No parades, smaller celebrations, but it still has been a historic month when it comes to LGBTQ rights, perhaps more so than any other since marriage equality became the law of the land in June 2015. A few days ago, the Supreme Court ruled that the Civil Rights Act of 1964 protects LGBTQ Americans against discrimination in the workplace. The majority said an employer who fires an individual merely for being gay or transgender defies the law. Now, this ruling was a little bit of a surprise. I mean, it was absolutely correct in that it recognized that the law offers equal protection for LGBTQ Americans, a fact that should never have been in doubt. I also want to say on the floor today, we're going to have to continue to be on guard that this administration's judges will use the approach underpinning this ruling as cover to strip equal protection from other people in future rulings. When you get the wrong approach resulting in the correct ruling, we've got to be vigilant, and more vigilant in fighting for the correct results again and again and again. The ruling came just a few days after the Trump administration tried to take America in exactly a different direction, announcing that it was greenlighting health care discrimination against transgender Americans. An ugly, shameful action to take. How cruel that the administration actually said, Senator Merkley, we're going to announce this during Pride Month. We're actually going to use Pride Month to be cruel. It was a reminder to a lot of people that the fight for LGBTQ rights didn't end with the victory on marriage equality. For every landmark ruling that moves the cause forward, there's somebody like Donald Trump who's always looking to see if they can drag the nation back to the days when discrimination was business as usual. Until Monday's ruling, employers in more than half the states were allowed to fire employees for their sexual orientation or their gender identity. That was in more than half the states, Mr. President. But that injustice is now a thing of the past. We can't count on this week's Supreme Court ruling against workplace discrimination to bring on the end of discrimination in other parts of life in our country. The Senate can't wait for any other court cases to move forward before we take real action on this floor. That's why my colleagues and I are here today. We want to call for the immediate passage of the Equality Act. If discrimination against LGBTQ Americans is illegal in the workplace, then it is illegal in housing. It's illegal in education. It's illegal in public services and more. That's what the Equality Act is all about. It's about recognizing the dignity and the humanity of LGBTQ Americans, and most importantly, enshrining it into the law. It's the next step that will move the cause forward, and there's bipartisan legislation that reflects the will of an overwhelming majority of the American people. The Senate ought to come together and pass it now. Justice Kennedy wrote, and I'll close with this because it sums up what's in my heart today, the Constitution promises liberty to all within its reach. There's much to be done on delivering on that promise outlined by Justice Kennedy. So we're going to be back here on the floor of the Senate fighting for the passage of the Equality Act. Senator Stabenow was spot on. We ought to have done it today. And we're just going to be back here again and again and again in the weeks and months ahead until we have that promise of equality in every corner of the land. Mr. President, I yield the floor. And I yield the floor to Senator Bennett.
Thank you, Mr. President. Mr. President.
Senator from Colorado.
Thank you. I want to thank my colleagues from Oregon, Senator Wyden for his remarks, Senator Merkley for his leadership on the bill, and Senator Baldwin from Wisconsin for her extraordinary leadership and service to our country. It is a great privilege to be here today. My friend Cory Booker from New Jersey, who's been fighting for these issues for his whole career. And who knows, as I know, that anyone who's studied the history of our democracy knows it's always been hard to make progress. This struggle has always been a battle of our highest ideals and our worst instincts as a country. It's been true since our founding, when the same people who wrote that all men are created equal also perpetuated human slavery and denied equality to so many others. In fact, I don't think it's too much to say, Mr. President, that our history is a story of our struggle with that contradiction between the promise of equality and the reality of inequality in America, between our highest ideals and our worst instincts. We struggle with that today. Since he took office, over and over, President Trump has called on our worst instincts in almost everything he's done, including his attacks on access to health care, housing, and education for LGBTQ Americans. Just last week, he went out of his way to strip transgender Americans of their access to health care. But just as President Trump was depriving hard-won rights, dragging us backward again, in Colorado on the very same day, colleagues, Our state legislature passed a law to make it harder to wage violence against LGBTQ people in my state. And listen to this. The vote was 63-1 in the Colorado House. It was 35-0 in the Colorado Senate. Notwithstanding President Trump's anti-civil rights, anti-civil liberties agenda, in Colorado, a western state, a purple state, Republican and Democratic elected officials in their legislative season are fighting for our highest ideals and rejecting our worst instincts. In fact, my state passed our version of the Equality Act over a decade ago. It's why we banned conversion therapy and passed Jude's Law, which makes it easier for transgender Americans to change their name in government documents. It's how we've elected our state's first openly gay governor, Jared Polis, and our first transgender state legislator, Breonna Tattone. It's why we were one of the first states in America, I say to my colleague from New Jersey, to pass real accountability for police brutality with a bill led by Leslie Herod, Colorado's first LGBTQ state legislator of color. This week, we passed that bill 52-13 in the House and 32-2 in the Senate. It contains many of the same reforms that Senator Booker and Senator Harris are leading on here. So I'm here to tell you that more and more Colorado and the country understand what equality has come to mean in America, how to resolve some of these contradictions in the year 2020. And this week, even the United States Supreme Court seems to understand it. Just in the last week, a Republican-appointed justice rejected Donald Trump's arguments and wrote for a majority of the court affirming equality for LGBTQ Americans. And this morning, Mr. President, the court overturned President Trump's malicious attack on Dreamers, reaffirming the rule of law, and for the moment, protecting 750,000 people who know no other country but the United States of America. And now it's time for the Senate to do our work, finally, and pass the Equality Act. The House passed the Equality Act 13 months ago, and we've not acted in our typical fashion. That's another 13 months when LGBTQ Americans could get married on a Sunday and fired on Monday. Another 13 months when our neighbors could be denied housing, denied health care, or be turned out of a store because of who they are. Mr. President, Americans understand that no good comes from hoarding freedoms and equality. When we take the opposite view, we act against our traditions. As a nation, we will never flourish if we choose to depend on a permanent underclass, deprived of some or all of the rights and freedoms others enjoy. Free people do not remain free by denying freedom to others. We should vote on the Equality Act and pass it today.
Mr. President.
Senator from Minnesota.
Mr. President, I join my colleagues today in the middle of Pride Month to celebrate the Supreme Court's landmark decision this week in Bostock v. Clayton County, protecting LGBTQ rights, protecting people from discrimination in the workplace, and urging all of our colleagues to secure and extend those protections by passing the Equality Act. Something else big happened in the Supreme Court, and that was today with the Supreme Court's decision on DACA, on Dreamers, allowing them to stay in this country and asking the administration to open up the application process for citizenship. That's relevant because it's about civil rights, but it's also relevant because the Supreme Court, this conservative court, has had to step in because this body has not been doing what it should, passing the Equality Act, passing comprehensive immigration reform. So let us remember that as we celebrate the decision in the Bostock case, and also as we move towards equality. I'd like to thank Senators Merkley, Baldwin, and Booker for their leadership on this important bill and for bringing us together today. Over the last few decades, we have made progress in the fight for equality. We stood up for what is right, and we worked hard to make this a country where people can safely, proudly, and legally love who they love. It wasn't long ago that a person could be prosecuted for being gay. Don't ask, don't tell was the law of the land when I came to the United States Senate, and states were permitted to deny LGBTQ couples a right to get married under the Defense of Marriage Act. This week, our country took an important step forward with the Supreme Court's decision recognizing that the Civil Rights Act of 1964, which prohibits employers from firing an employee because of sex, protects LGBTQ people in the workplace. Today, we can celebrate that justice was delivered for Amy Stevens, who was fired when she informed her employer that she was transgender, and for Donald Zarda and Gerald Bostock, who were fired when their employers learned they were gay. But of course, this is more than about three people. As Mr. Bostock said, this fight became about so much more than me. Their courage to stand up in the face of injustice will forever change this country for millions of LGBTQ people, their families, and it makes our country a more just nation. Although Monday's decision is a landmark victory, we still have miles to go, because it's not right when the Commander-in-Chief tells brave transgender Americans who want to serve and defend their country in our military that they are not welcome. It's not right when this administration is trying to take away the hard-won rights of LGBTQ people in healthcare and education. And it's not right that you can drive across the United States on a cross-country trip and the laws and protections could be different at every rest stop you make. That's why I was proud to co-sponsor the Bipartisan Equality Act the day it was introduced with my colleagues that are here today, and why I am calling on our colleagues across the aisle to pass this bill. This bill, which already passed the House by a vote of 236 to 173, will go a long way to protect LGBTQ Americans from discrimination. The Equality Act would build on the Supreme Court's decision and make non-discrimination protections consistent and explicit. It would amend laws like the Civil Rights Act, the Fair Housing Act, the Equal Credit Opportunity Act, and federal employment laws to ensure that all Americans are entitled to equal access to housing, education, and federally funded programs regardless of their sexual orientation or gender identity. We should not wait any longer to extend these protections. Nearly 2/3 of LGBTQ Americans report experiencing discrimination in their personal lives. These problems are compounded by race and income, especially for trans women of color, and yet it's been over 1 year since this bill passed the House. In 2000, when I was the county attorney in our largest county in Minnesota, I was invited to the White House to introduce President Bill Clinton in an event to urge the passage of hate crimes legislation. We had had an African-American young man who was shot by a guy that said that he wanted to go out and kill someone on Martin Luther King Day. That happened. We had had an employee that got beaten with a board in his workplace by the foreman for simply speaking Spanish. And I had taken on a number of these crimes, and so I was invited by the president to urge Congress to pass the Matthew Shepard hate crimes legislation that covered a wide range of hate crimes. During that event at the White House, my first time ever there, I got to meet the investigators in the Matthew Shepard case. They were these two burly cops from Wyoming, and they talked about the fact that until that investigation, I think Senator Baldwin is nodding her head and has probably met them as well, they really hadn't thought about what Matthew Shepard's life was like or the lives of other LGBTQ people. And then as they started to investigate what happened, and we all remember how he was left hanging on a fence post, and the first people that saw him thought he was a scarecrow, these investigators, these police officers, got to know the family in the case. They got to know his mom, and they got to know his friends. And in the course of their investigation, as they began to understand what life was like for Matthew Shepard, their own lives were changed. I think this is happening right now around this country after the murder of George Floyd in my state. And I know it's been happening when it comes to our LGBTQ community. And that is why that day way back, we were in the White House to introduce that bill. Nearly 10 years after that event at the White House, during my first year as a U.S. Senator, I got to be one of the deciding votes to finally pass that hate crimes bill. So I say to my colleagues who are fighting for justice, in policing, who are fighting for justice for our LGBTQ community, who are fighting for justice for our immigrants, that change happens. But we can't wait 10 years for all of this change to happen. The people of this country are demanding that it happens now. We need to come together and finally pass the Equality Act and do all these other good things that are right here, right on our desks, and we should do them immediately. Not next year, not waiting, now. Thank you. I yield the floor.
Senator from New Jersey.
Thank you, Mr. President, for the recognition. I want to thank my colleagues that are here and for all the work that's been done, not just here in the Senate, but also in the House of Representatives around the Equality Act. I want to make this very clear. We at this body, you look at history, you see that the fundamental equality of all Americans has been denied in so many generations. Women who fought for equality under the law, the right to vote, African Americans who fought for equality under the law. We have seen from our founding are struggling to make real on the promise of this nation, this promise of an ideal that we are all equal under the law. Our founders, these imperfect geniuses, enshrined these ideals. This nation was not founded in perfection, but in aspiration. The very founders themselves referred to Native Americans as savages. It talked about women not being equal citizens. It denied African Americans full and equal citizenship. Yet these aspirational documents were so profound that every generation of Americans has called to our founding ideals to overcome the inequality that was inherent in our country. Susan B. Anthony calling to the founding documents for her equality and the equality of women. Martin Luther King on the Mall calling to that check promissory note, calling that it was time. And here we are in the year 2020, still calling for the full equality of all American citizens when it comes to lesbian, gay, bisexual, transgender Americans. And I think back to my own family, grandparents and great-grandmother who would talk about the excuses that were used to deny them equality. There were religious excuses. I'm a big believer in religious freedom. But people sought to deny blacks and whites from marrying. In fact, when Loving v. Virginia passed, the majority of Americans were still against interracial marriage in this country. But somehow, people who were using religion to shield from the fundamental ideals, from establishing the fundamental ideals of this country, we overcame that. These types of reasons were given for the dehumanizing treatment to Native Americans. These kind of excuses were used to justify the segregation of African Americans. But every generation, we fought and we struggled and we came together in multiracial, multi-ethnic, diverse coalitions to overcome. This week, I was so grateful to see the decision of the Supreme Court, but I was of mixed feelings about it. Why would it take an action of the Supreme Court to justify what already is equal humanity, equal dignity? Why would it take so long for a country to say, in this nation, the majority of states cannot discriminate against you? You cannot be fired just because of who you are. I hear the echoes of my own ancestry, growing up in a country where children see clearly before them being told and enshrined in laws that are bigoted and biased that you are not an equal citizen, even though when we stand up in our grade schools, we have to say those words, liberty and justice for all. What does it mean to a child that is denied those things? I see us in a country now where we're raising children who are in danger. LGBTQ kids are almost 5 times as likely as their straight peers to attempt suicide. LGBTQ kids, about 30%, admit missing school because of fear for their safety in America in 2020. Black trans women dying at unacceptable, unconscionable rates. I say dying, being murdered. 15 transgender or gender non-conforming people have been murdered. And last week alone, 2 transgender black women were killed, Dominique Fells and Raya Milton. We have work to do in this country to establish the fundamental ideals that have been said from the founding of this country, that we will all be equal under the law. The fundamental ideals from the founding of this country, that we are a nation of liberty and justice for all. And see, here we are at the crossroads of history, forcing our fellow Americans to come and ask for what is fundamentally theirs already. Equal dignity, equal rights. This equality law the Equality Act is too late already. It's too late to do what was foreordained by the very founding of this nation. We are too late already to save the lives of children who've been forced to live in a nation that doesn't recognize their equal dignity. We're too late already to protect the shame of people who've been fired just because they're gay, who have been denied accommodations just because they're gay. The humiliation that I dare say so many in this body know from their families' stories. And so we come here to the floor today to ask for what is overdue, to ask for us to establish in law what is true in the spirit of this nation. To echo the words of our ancestors, great suffragettes, great civil rights leaders, great Native Americans who've all come to this Capitol to say this is who we are, equal citizens under the law. And so to my colleagues who are with me today, I tell you that no matter what happens with this unanimous consent, justice will come to this country. No matter what person stands against this Equality Act, they stand on the wrong side of history. The arc of the moral universe is long, but it bends towards justice. Well, it never bends automatically. We need some arc benders. And for too many people in this country, justice delayed is justice denied. And so we will not give up, we will not yield, we will not equivocate, we will not retreat. This will become the law of the land. We have made some steps in the right direction of justice, but we are still in the foothills. We have a mountain to climb, but I know we will make it to the mountaintop. I know that this nation will fulfill its promise to all of its people and indeed become the promised land. Thank you. I yield the floor.
The Senator from Oregon.
Mr. President, I appreciate the powerful words, the passionate delivery of stories, the defense of freedom, the defense of equality, the advance of justice, and the presentations of my colleagues from Wisconsin and Michigan, my partner from Oregon, my friend from Colorado, the senator from Minnesota, and Senator Booker from New Jersey. Their words speak to the heart of what our nation is about: equality, opportunity, justice, and freedom. I will therefore ask that we bring this bill about equality to the floor, that we go forward in the great tradition of this chamber, this Senate, to debate issues that involve the opportunity for every individual to thrive in our nation. We've held those debates before, time and time again. We held them in 2013 on the Employment Non-Discrimination Act. Now, I understand some colleagues have come to the floor to object to this Senate entertaining such an important debate. They've come to the floor to obstruct the opportunity of this chamber to engage in a dialogue on this important issue so vital to the life of millions of Americans. I ask them, reconsider. Have the courage to debate this issue on the floor, to bring in the great tradition of this country an issue vital to freedom to be considered here. One colleague responded to the Supreme Court decision on employment non-discrimination earlier this week by saying, this judicial rewriting of our law short-circuited the legislative process and the authority of the electorate. Well, let no member of the Senate today short-circuit the legislative process by objecting to this important debate on the floor of the Senate. Madam President, on behalf of equality and opportunity and freedom, I ask unanimous consent that the Judiciary Committee be discharged from further consideration of H.R. 5 and the Senate proceed to its immediate consideration. Further, that the bill be considered read a third time and passed, and that the motion to reconsider be considered made and laid up on the table.
Is there objection?
Madam President.
The senator from Utah.
Madam President, reserving the right to object, there is a single thread that runs through the Supreme Court's decision in the Bostock case earlier this week and all the way through the legislation now under discussion on the Senate floor. And that principle deals with non-discrimination. The principle that as Americans, we believe that people shouldn't be treated differently on the basis of factors, characteristics, traits that have nothing to do with their job. I think most Americans can agree with that. And I think most Americans can agree that an individual shouldn't face such discrimination in the workplace based on his or her sexual orientation. The important thing that we have to remember is that much of where the law is found and much of what we can perceive from a position of justice and equality and fairness relates to where the exceptions are found. I've got two principal concerns with this legislation that are also shared by the Bostock ruling. The first relates to exceptions related to religious employers. Neither the Bostock decision nor the Equality Act takes the care to ensure that religious employers will be treated fairly under this approach. We need to be mindful of the need of a religious employer to maintain its doctrine and its teachings, not only in the hiring of its ministers, but also in the hiring of other people who work toward moving forward that religious institution's teachings in the way they live their lives, in their beliefs, and in their willingness to teach those things to others. This legislation doesn't do that. And I think any legislation that we move forward on this needs to have that. Secondly, neither this legislation nor the Bostock decision takes into account some significant distinctions between sexual orientation on the one hand and gender identity on the other. In the case of gender identity, the law needs to take into account certain questions regarding what impact the law might have on girls and women's restrooms and locker rooms, girls and women's athletics, single-sex safe places for people who are, for example, the victims of domestic or sexual abuse. This law, like the Bostock decision, doesn't operate with a lot of precision and sort of takes a meat cleaver to the issue without taking into account exceptions for religious entities and distinctions between sexual orientation and gender identity. On that basis, I have concerns. Noting that I've got some colleagues who want to speak to this issue at all, I decline to object as of this moment.
The senator from Missouri.
Madam President, reserving the right to object, I'd just like to observe that it was just over 20 years ago that this chamber and an analog chamber across the way in the House of Representatives passed almost unanimously a statute called the Religious Freedom Restoration Act. It was sponsored in the House by then Representative Schumer, and it was sponsored in this chamber by Senator Edward Kennedy and signed by President Bill Clinton into law, who, upon its signing, referred to religious liberty as our first freedom. Those are his words. And he later pointed to the Religious Freedom Restoration Act as one of his proudest accomplishments as President of the United States. Its co-sponsors in this body included Senators Feinstein and Murray and Leahy. It was bipartisan, is my point, to put it mildly. And yet today, this short time on, the legislation that is offered on this floor now, that has not gone through the normal process of committee referral, debate on the floor, but would be passed now without any further discussion, guts key provisions of the Religious Freedom Restoration Act. This coming on the heels of a Supreme Court decision just 2 days ago that rewrites entire statutes in American law, and in its 33 pages has nearly nothing to say about religious liberty or religious believers in this country. In fact, the only thing that the opinion does say of any consequence is this, and I quote, "How the court's doctrines protecting religious liberty interact with Title VII, as rewritten by the court, are questions for future cases." Now, I respect very much my colleagues across the aisle and their passion for this issue and their sincerity in this cause. I would only ask that the rights of well-meaning, sincere religious believers not be steamrolled and overlooked and shifted to the side as part of this process. We should be able to come together and stand together in the effort to see all people be given their constitutional rights, have their constitutional rights protected. But the effects of this bill, forcing taxpayers to pay for abortions, forcing doctors and nurses to perform abortions against their will, forcing faith-based hospitals and clinics to perform abortions. H.R. 5, this bill here, would supersede existing restrictions on abortion, including funding, including health and safety standards, and other regulations that the states have passed. It would force faith-based adoption agencies, some of which have been helping birth mothers find a safe and loving and permanent home for more than 100 years. It would force them out of business. It would coerce those who don't want to speak or who hold different beliefs into adopting this set of practices and principles and beliefs at work. These doctors, these nurses, these faith-based agencies. I submit to you that this is not the way to find consensus in America. This shunting aside of the constitutional rights of sincere, well-meaning people of faith is not the way to proceed. And this gutting of the Religious Freedom Act, and I say that because H.R. 5 explicitly carves out of the Religious Freedom Act, it explicitly carves out of its safety provisions all of those requirements I just mentioned. It rolls back the liberties afforded to people of faith. All faiths, by the way. One of the beauties of the Religious Freedom Restoration Act is that it covers people of all faith, any faith. And this bill would roll those protections back, and it would do it without the chance for debate. It would do it outside of our normal procedures. And so, for those reasons, Madam President, I express these reservations. Again, I want to thank my colleagues on the other side of the aisle for their work on this issue, their passion for this cause, and their sincerity in what they believe. And I hope that we might find a better way to go forward together. But, Madam President, I do not object.
Madam President.
Senator from Oklahoma.
Reserving the right to object. No person should be discriminated against in America. No one. It's a basic constitutional principle. We're all equal under the law. All of us. We have different ideas about music and food. We have different ideas about sexuality. We have different ideas about occupations. We have different skin colors. We are the tapestry that we talk about. And we are working to make a more perfect union. And I absolutely believe that no person should be discriminated against in America. The Equality Act doesn't just make everything equal, though. It has a great title. Who can oppose equality? No one. It's a basic principle of American values. We don't oppose equality, but we do oppose when through legislation you take the rights of one and dismiss the rights of others and say, your rights don't count, only this group counts, only this person counts. We in America have tried to work together in all of our differences for over 2 centuries to learn better how to be able to hear the rights of another one, to be able to accommodate and to be able to find those spots where the rights collide of 2 individuals and to be able to work it out among each other. The Equality Act does not do that. I wish it did. It changes things dramatically. Let me just give you a few examples. It reaches into high school sports and says for male and female sports that individuals, sexual orientation, gender identity, can move between those. There is no standard for testosterone. There is no standard for moving through transition, surgery. There is no standard at all set on it. It opens it up for any male, biological male, to step into female sports on the high school level or in the college level or in the pro athlete level and to be able to move into that sport. That grossly disadvantages girls in sports. But their rights are denied. We've already seen this in several states, where state record holders for track, for instance, someone that was a biological male competing in women's athletics, denying the other girls that were competing in that from opportunities from scholarships to college to be able to move on to other athletics. Their rights were ignored because these rights were prioritized. In adoptions, we need more adoption areas. We need more foster care in America, not less. The Equality Act says that if you're a faith-based adoption agency that only places children in the home where there's a mom and dad there, then you either have to change your faith or close. You have no other option. So the Equality Act says to that institution, I would rather have fewer adoption agencies in America than have you open. That's not protecting the rights of all Americans. That's not us learning how to accommodate together. Why can't we have adoption agencies that do adoptions in LGBT homes and some that do adoptions that don't? Why can't we have both? Why can't we accommodate both? The Equality Act does not allow that. The Equality Act treats every job in America exactly the same and says that an individual that is qualified for that job should be able to take that job regardless of any issue. So let me give you a first example of that. If you're an individual going through TSA, and what a lovely experience that is for all of us, this Equality Act would say when your alarm goes off and you have to get the full body pat down, transgender individual could be your TSA person giving you the full body pat down. They would be required to not prohibit that. Now, for some people, they'd be like, I don't care. I don't care. It's just a pat down. I don't care. For other people, it'd be like, there's a reason that TSA has done pat downs a man for a man and a woman for a woman, because there are many people uncomfortable with someone of an opposite gender that does that to them. They just are. Maybe you can call them prudes, but we've honored their rights. The Equality Act does not. It ignores their rights. and says, you no longer have the right to disagree with this. You have to just accept it. It also dramatically changes hiring in America in a way that is unexplored. There's a reason that we send bills through committee, not just bring them to the floor and demand that they pass on the same day they land on the floor without going through committee. There's a reason we do that. Because this bill changes the way hiring is done in America in a way that has not been tested for everyone. This adds a new feature to Title VII, where it says in Title VII that you can't discriminate based on race, on sex, that's now been redefined obviously by the courts, on religion, age, all this thing. It clarifies you can't discriminate based on that, but it adds a new phrase on this. Perception or belief is the new phrase. So this is how that would be applied in the courts. If I go to interview in a job and I'm not hired, I can sue that employer because I perceive they were thinking I was gay and so they didn't hire me. Or because it applies to all of it, I could actually, because this does expand this significantly, if I go in to get a job and I'm not hired, I could sue them for not hiring me because I perceive I was a Christian and they didn't hire me. I perceive that it's because I was white they didn't hire me. I don't have to prove anything. It's based simply on my perception or belief. That is an untested expansion. Now, this term perception or belief is lifted right out of our hate crime statutes, but hate crime statutes on their face are all about the motive for it. And you're trying to read into a crime the motive for that crime. Now we're trying to literally read someone else's mind in a hiring situation and to say, I perceived it, so if you don't hire me, I can sue you. Why are we doing this? That opens up litigation all over the country on every area, not just in this issue of LGBT rights, on every situation and every hiring, because it's very expansive. We probably should slow down and look at that before we open that floodgate in America. But this does not. Today is about demanding that it passes right away. Interestingly enough, as some of my colleagues have mentioned, the Religious Freedom Restoration Act is wiped away in this and ignored. Interestingly enough, the Supreme Court stated just this week that on this issue that Congress should apply this. Let me read what Justices Ginsburg, Breyer, Sotomayor, Kagan wrote this week, along with Roberts and Gorsuch. They said this: separately, the employers fear that complying with Title VII's requirements in cases like ours may require some employers to violate their religious convictions. We are also deeply concerned with preserving the promise of free exercise of religion enshrined in our Constitution that guarantee lies at the heart of our pluralistic society. And they go on to speak of, we will have a case dealing with the Religious Freedom Restoration Act. The Equality Act instead says, no, never mind, Supreme Court. I know that you're concerned about religious freedoms, Ginsburg, Breyer, Sotomayor, Kagan, Gorsuch, Roberts. But never mind, Congress is not concerned with religious liberty like you are. Come on, let's work together. We don't want anyone to be discriminated against, anyone. But we can do this in a way that accommodates everyone, and that we can actually work towards agreement. Or to say it in the words of J.K. Rowling this past week, where she wrote, all I'm asking, all I want, is for similar empathy, similar understanding to be extended to the many millions of women whose sole crime is wanting their concerns to be heard without receiving threats or abuse. Let's work together to get equality. This bill does not do it in this form. Therefore, I object.
Objection is heard.
Madam President.
The Senator
Madam President, I'm disappointed that my colleagues have come to the floor to stand in the way of a debate in this esteemed chamber over issues of freedom, issues of opportunity, issues of equality, that affect millions of LGBTQ Americans. And what did we hear in their conversation? My colleague from Utah says, there's no chance for debate. Has my colleague forgotten that bringing a bill to the floor brings it to debate? Is that such a lost art in the Senate that my colleague thinks debating a bill on the floor somehow squelches debate? It's a mystery to me how one could make the argument that bringing a bill to the floor kills debate. My colleague from Oklahoma laments there's no committee action. Well, my colleague might be reminded that for 400 days, his party has controlled whether or not there is committee action on this bill. Yet it's a majority that decides whether or not a committee addresses the issues before it. Is not 400 days of inaction in committee an argument to have the conversation here as a committee of the whole? Isn't that what we're asking for? A committee of the whole to debate these key issues. My colleagues also refer to how somehow this bill affects religious rights. And I'm taken back through the history of the conversation and dialogue about equality and opportunity in America, how every time we seek to end discrimination, someone says, but wait, religious rights. Remember that this was the argument against black and brown Americans from having equality here in the United States of America, because their religion said they're not equal and they shouldn't be let in the door. And I should have the right to not let them in the door. I should have the right to discriminate. And isn't that the conversation we heard around the opportunity for women in America to play a full role in our society? That people had a religious foundation for discriminating between men and women. Well, I tell you, this nation, although imperfect, was founded on a vision that everyone is created equal and has a full chance to participate. And we've worked over hundreds of years to get towards that goal, that every child can thrive in America, no matter their gender, no matter the color of their skin, no matter if they identify as gay or lesbian or bisexual, no matter if they're transgender. That is the conversation we should be having here. I feel the injury of a Senate that's no longer a Senate, where people tremble in their seats over the idea of having a debate. What happened to this esteemed body that should be the case? So let us not rest. For those colleagues across the aisle who have said the Supreme Court shouldn't have acted this week, that it should be the legislature that acts, and yet come to the floor and don't argue, fail to argue that we should in fact act. Isn't that obstruction of the legislative process? So I encourage my colleagues who say there are important issues to be considered to go to their leadership and say, let's get the committee that has this bill, the Equality Act, to start doing its job. Hold the hearings, hold the conversation. Because to fail to argue that it should be done in committee while you lament on the floor that the committee hasn't acted is certainly an argument with no integrity. Madam Chair, I yield the floor to my colleague from New Jersey. Yield the floor.
Madam President, I rise today.
Senator from New Jersey.
Thank you very much, Madam President. I apologize. Madam President, I rise today to discuss the Confederate monuments that are in our hallowed halls of Congress and would like to make a live UC request, but preceding that request, just to make a few very brief remarks. The National Statuary Hall, where these Confederate statues are, in the Capitol, it's intended to honor the highest ideals of our nation.